Thanks, Mr. Rao. I'll ask a few questions. I'm going to make a statement which I hope you'll both listen to carefully. Under the Tobacco Control Act, a manufacturer has the burden of proving to the FDA that its e-cigarette is, quote, appropriate for the protection of the public health, end quote, before it can enter the market. In other words, unless the manufacturer meets its burden and the FDA authorizes the product, it is illegal for that e-cigarette to be sold in the United States. Dr. King, Mr. Rao, is everything I've said so far accurate?
Yes, correct.
Yes.
To date, the FDA has authorized 23 e-cigarette brands, and no flavored cigarettes have been authorized by the FDA. Take a look at this photo. It was taken by my staff just a few days ago at a vape shop less than 1 mile removed from the FDA's headquarters. It shows Fat Boys, Red Bull, Strawberry Vape, and V-Hose Dragon Fruit Watermelon Vapes. Right here is this so-called Elf Bar Watermelon Bubblegum Vape purchased from that store less than 1 mile away from the FDA headquarters. Not a single one of these products has been authorized by the FDA. None of them. These illegal products, clearly designed for kids by their flavors, are being sold in FDA's shadow of their building headquarters, less than a mile from your headquarters. How is that allowed to happen, Dr. King?
I'll reinforce that we do have a pre-market paradigm for reviewing applications, and the sheer volume of the volume of those applications and the volume of the market requires us to prioritize our enforcement efforts.
That's what I really want to get to here. So you're saying that if they're burden of proof on the manufacturer under the law, they have to prove appropriate for public health before they will be approved by the FDA. That proof is not made, and yet these products are going for sale. You've completely fallen down on the job. Your responsibility is to impose the burden of proof and not allow the sale of these e-vape cigarettes to kids unless they are approved by the FDA, correct?
Correct.
So let's hear the answer.
I'll reinforce that the sheer volume of this product landscape requires time to ensure that we conduct scientifically defensible and legally defensible reviews of the 27 million
That's
applications.
That's not your burden. It's their burden. They have to prove they're appropriate for public health. You don't have to disprove it.
I'll reinforce that the applications are substantial, and we have hundreds of scientists that are working on a daily basis to review these applications, and we've made good progress. We're 99%
So if I make a filing,
through.
if I file legal briefs thick enough, I can go ahead and sell my product without approval.
No, that's not accurate, but we want to make sure we review the science that's submitted. And so there are some applications that don't meet the initial bar. There's 3 phases of review, and we can remove those applications earlier if they don't have the necessary information. But if they provide enough science for us to do a substantive review, we have to take the time to scientifically review them, and that does take time.
Mr. Rao, are these tobacco company lawyers beating you to death to the point where you don't enforce the law as it is written and I described it? Please use your microphone.
Senator, this is obviously a very litigious environment. We have been actively defending the FDA in courts of appeal and district courts across the country.
33 months since the Maryland court said you were required through the FDA to get your job done, and nothing has happened.
Senator,
you call this an urgent need. What is urgent about waiting almost 3 years and doing nothing?
Senator, we share your concerns with respect to the widespread prevalence of these illegal products, and we take seriously our obligations to enforce aggressively in this space.
I assume you're an attorney, are you not?
That's correct.
What does it mean when we say burden of proof?
What needs to be established in a court?
Who has the responsibility of proving the safety of this product now under American law?
In this case, it would be the manufacturers.
Have they proven it with all these?
I do not believe that's the case. No, they have not.
So what should we do as a nation to say to them, you cannot, in this situation, openly defy the law and the agencies and sell your product anyway to children?
Senator,
what is it we should do to stop them?
Senator, I think we should signal aggressive aggressive enforcement in this space is a priority across the executive branch. I think we should send that signal. I appreciate the opportunity to
I'm
lift
sorry.
up.
I'm sorry. I'm against signals. Do something. To announce 7 days before this hearing that you're going to have real law enforcement now get involved in this. What in the hell have you been waiting for?
Senator, we have been acting on a number of fronts. There's been the civil monetary penalty actions that Dr. King referred to earlier, and the department stands ready to assist in collection actions in those matters. We have been working with the U.S. Marshal Service and the FDA on seizures.
You're failing. You're failing within a mile of the FDA headquarters. Is evidence that you're failing. What's serious about this is not only the failure of the attorneys, but the failure that is leading to addiction of children.
Senator, this is a multi-pronged approach. That's what's going to be required in this case. And again, that's why we're working with multiple law enforcement partners, not just the FDA, but also the Bureau of Alcohol, Tobacco, and Firearms, U.S. Postal Inspection Service. We have had ongoing engagement with those agencies, looking at potential additional enforcement actions, both criminal and civil, that we can take using other authorities. And we are optimistic that working with these partners, we're going to be able to make progress.
Well, it's been quite a few years since I finished my law school courses, but I do believe I understand burden of proof. They have the burden of proof. They have failed to meet it and sell their product regardless. Our government, Department of Justice, and FDA stand by and say, this is too complicated. It's not complicated. It's basic. If they have the burden of proof and haven't met that, they are violating the law, correct?
Correct.
Enough said. Senator Tillis.